Constitutional Court will today hear arguments in a landmark case about consent in sexual offences, including rape. In terms of the Sexual Offences and Related Matters Act, a person charged with rape can avoid conviction if they can show it is reasonably possible that they believed the complainant had consented to sex. This defence does not require showing that consent was actually given. Now, last year, the High Court in Pretoria ruled that certain provisions of the Act were unconstitutional because they failed to protect victims. Newzroom Afrika's Zoleka Qodashe is following that story. She joins us live from the Apex Court. So, Zoleka, on the one hand, there's this argument between where the onus lies to prove consent in cases of sexual assault and rape, sexual offences cases. On the other hand, it's also about how the law is applied, right? So there is also a discussion to be had about the fact that the Act itself is fine as it is, but it's actually with the application of the law in the lower courts.
That's correct, Michelle, and that is why the Gauteng High Court in Pretoria granted that order of constitutional invalidity insofar as the Act or various provisions of the Act allow an accused person to use the defence that they reasonably possibly believed that consent had been granted. And that's why the applicants are before the Constitutional Court today for confirmation of that constitutional invalidity in terms of Section 172 of the Constitution. You'll know that whenever a court grants an order of constitutional invalidity, the Constitutional Court then has to confirm it for that order of constitutional invalidity to have any legal force. And so that is why the parties are before the Constitutional Court. But what we'll also see before the Apex Court in Johannesburg today is an application for leave to appeal the whole judgment of the Superior Court in Pretoria. Now, what we saw unfold in September last year is that this application by Embrace Project, while that was granted for various provisions of the Sexual Offences and Related Matters Act to be declared inconsistent with the Constitution, what we're going to see here is an appeal by the Centre for Applied Legal Studies, where they argue that there's a different application of the law that must be exercised. So what they want is, and I want us to perhaps zoom into what Section 3 of the statute actually says. It says, or it stipulates, that a person who intentionally and unlawfully commits an act of sexual penetration against a complainant who might be person B without their consent shall be guilty of the offence of rape, or shall be guilty of rape. Now, what Kels argues is that these three definitional elements, while one of them being consent, must be struck from the definition of what rape is. So we know that it is one of the definitional elements is the intention, 2 is consent, and 3 is unlawfulness. So they argue that consent shouldn't even be part of the definitional elements that describe what rape is. And they say this because oftentimes rape victims or rape survivors find themselves in a position where they cannot actually consent to the sexual conduct or the sexual act. And so they argue that the coercive-based model is the model that must be applied in rape matters. And this is important, Michelle, because Parliament and the South African law doesn't prescribe that model to be applied in rape and sexual offences matters. Instead, it is the consent-based model that looks at the absence of voluntary agreement or consent in sexual conduct or in sexual acts that would render a matter being rape or an act be constituting as rape. And so they argue, and this is what they argued before the Gauteng High Court in Pretoria as well, that that is the incorrect model that is applied in rape matters. But the High Court dismissed Kels's application, saying that this is a breach of separation of powers because you'll remember that because it relates to policy, policy speaks to executive action. And that is because the executive must be allowed to take decisions that affect various policies. And so when a matter looks at policy, that is executive action. And so the courts are quite
Sorry to interrupt you there. I just want to, before we get to the issue of executive action and policy, I want to stay with this issue of consent. I get what you're saying about the argument by the Centre for Applied Legal Studies around consent, because in many cases, particularly involving underage children, consent obviously is not possible, right? Up until a certain age, even if there is tacit agreement of sexual activity, the consent flies out the window because that person legally cannot consent to sexual intercourse. But isn't consent really at the heart of, outside of that example of the underage example, someone who's mentally incapacitated and the like, is consent not really at the heart of rape cases, particularly, for example, in a marriage or in a relationship? When, yes, we have been in a relationship for some time, but my consent was withdrawn, and that is what constitutes rape.
That's correct, Michelle, but also what is often looked at in rape matters, and in a lot of criminal matters, in fact, is also the intent. The court will look at whether the accused person intentionally committed the act of rape, and that's why that defense is particularly important, in that an accused person can say, well, I did not intend to commit such an act. And so while it is about consent, in this particular matter, it's also about intent. So what the applicants want is to shift it from looking at intent and instead looking at consent. Because, of course, as you mentioned, in intimate partner relationships, there is that often wrongful belief or wrong belief that the consent is implied simply because of the nature of the relationship. And so consent is at the heart of this matter, and that's why the Gauteng High Court in Pretoria granted that reading in the statute in the form of section 56(1)(a) of the statute, which reads that a person cannot use the defense, or that defense is no longer valid in that they believed that there must be consent. Instead, they need to demonstrate to the court that they took objectively reasonable steps to ascertain consent. So you are correct, Michelle. Consent is at the very heart of this matter, and that's what the applicants will argue before the Constitutional Court, that this must be confirmed so that it has legal effect.
It's an incredibly important judgment taking place there in the Constitutional Court, Zoleka, particularly